I played. We'll talk off the record, John. Yeah, I played for many years.
Well, maybe I'll see you in Orlando. You can tell me.
Okay, sounds good. Yeah, I played for many years for a team in Gary, Indiana.
Okay.
Of all places. So
one of our directors at Pacific West, her son was the first pick of the Tampa Bay Rays in one of the drafts recently.
Oh boy. Yeah. Well, yeah, good for him. It's exciting.
Oh shit! He had a scholarship to Tennessee, which is where I live, and he chose to play professional ball. I guess the 7 figures was more attractive.
Yeah, who knew that? Yeah, and Tennessee, very good team this year.
We'll see. We're pretty excited. Yeah. I live in Nashville, or near Nashville, but most of us are volunteer fans.
Yeah, yeah. It starts today, I think, or tomorrow. Yeah.
Tournament, yeah, tomorrow, I believe, in Knoxville for us. All right, so you're letting people in so they can actually hear us. So we should probably sound professional. All right. So tell me when you want me to get started. Let them.
Okay.
When we get to about 100, 150, I'll probably, because it's 12:01 now. So,
right.
Or excuse me, 10:01.
10:01, but we'll give them just a moment. Okay, we could probably go ahead and start now, John.
Okay, well, good morning, everybody. And as we continue to let people in, I want to make some introductions. First of all, thank you for participating today. A couple of years ago, we would treat the fair housing issues, which have always been important, but they were not front burner issues. Disclosure and all the other things that came up seemed to get a lot of airtime. But then all of a sudden, about a year and a half ago, with a lot of different things that we'll talk about today, fair housing is now a major front burner issue. And this is the second time we've done one of these programs. We're really, really excited about the panel that we have today. And I will proceed now to botch a few of the names. We have with us Eva Melgarejo. Did I say that correctly?
Yes, you did. Thank you.
Eva has a decade of experience with empowering communities. She has helped in the last couple of years over 300 families investing in real estate. And we're going to ask, and she's a member of a number of groups and is also on a city board in Long Beach for the chamber, and is going to talk to us about how you can talk to your clients about generational wealth building. There's a large gap between Caucasian and non-Caucasian property owners in California. And so Eva's going to give you some tips on how you could deal with that. We've got Steve Lerner. Steve is with the California Department of Real Estate, and he is the Assistant Commissioner for Legal Affairs, and he's held that position since November of 2015. And he is the principal legal advisor to the California Department of Real Estate. And he's going to talk about the real estate department's perspective on fair housing discrimination and how you can get into trouble. A couple of weeks ago, I attended the California Association of Realtors meeting and got to hear our second speaker, Matthew S. Kenefick. Matt is with a major law firm up in San Francisco, Jeffrey Mangels and Butler and Mitchell. And I told Lori and Laura when I heard him that it was without question in my mind the best presentation on ADA and website disability issues that I've ever heard. And so I immediately jumped on the horn and got Matt, and he was kind enough to agree. And then last but certainly not least, we have Mike Rohde. Mike is a staff attorney with the National Association of Realtors. He serves on the NAR Legal Action Committee. And Mike is going to talk about issues relating to what's going on at the national level, and particularly relating to advertising and an issue that comes up all the time at the association, disparate impact. So you're going to want to hear these guys. The good news is they're going to all talk, and I'm going to listen. And so we're going to start with Steve and the perspective on what's going on at the Department of Real Estate. So without further ado, Steve Lerner, DRE Assistant Commissioner for Legal Affairs. You're on, Steve.
Great. Thank you very much for that nice introduction, John. I'm going to try and share my screen. If I'm successful, you guys should see a slide that has my name and title on it. So with that, we're going to move forward. So hopefully you see the correct screen.
Perfect.
John, does everyone see the correct screen?
I know I do. It's perfect.
Yes, that looks fine.
Then we're ready to go. So as John mentioned, I'm the Assistant Commissioner for the Department of Real Estate. That's a fancy title for Chief Counsel. So I'm the Chief Legal Advisor to the department, the Commissioner, the executive team. I also oversee the legal program. And so we have about 25 attorneys that do primarily licensed discipline cases. So when an applicant who shouldn't have a license or a licensee who gets into a little trouble, in either case, those are the attorneys that take disciplinary action to either deny a license or to restrict or revoke a license. So it's my pleasure to work with a wonderful team of folks here at the Department of Real Estate. So as we move forward, let's see, just some disclaimers. I wouldn't be an attorney if I didn't have a few disclaimers to talk about. My presentation is for informational purposes only. I'm not trying to create any new policies or new rights. This presentation does not give you legal advice. And finally, it does not create any type of attorney-client relationship. So with that, I will move on to the major portion of my presentation. So here at the department, our mission is set forth in statute, and it's primarily and solely to safeguard and promote the public interest in real estate matters. And we do that through licensure, regulation, and education and enforcement. And in fact, if you are interested enough, if you go to Business and Professions Code section 10,050.1, it sets out what our highest priority is, and that's protection of the public. That always trumps everything else that we do. And so, like I mentioned, there's 4 ways we protect real estate consumers in California. And I'm really going to focus and touch on a little bit on the regulation, the education, and the enforcement components of what we do. And I'm taking it at a high level. The department itself has about 370 employees. So with 370 employees, we are responsible and have jurisdiction over 450,000 licensees. About 2/3 are sales licenses and 1/3 are brokers licenses or corporate licenses. So we do have a full plate of work here at the Department of Real Estate. Since this is a discussion on fair housing, I thought I'd start off with what is fair housing. And this is a long definition, but what it essentially means is for people searching for housing, people with similar backgrounds should have similar experiences in similar geographic markets. And there should not be any disparity based on basically protected classes. And I'll go through a list of protected classes that the various statutes, federal and state statutes, hold out. But you can see them in a very narrative format in this slide. And as I switch to the next slide, so essentially fair housing is really governed by 2 bodies of law. There's federal law and there's state law. And at the federal level, there's the Federal Americans with Disabilities Act and the Federal Fair Housing Act. And there's a bunch of other federal laws as well, but those are the 2 that we see quite a bit and have an undue presence in the fair housing arena. At the state level, there's a bunch of laws, but the 3 that we see the most of and that are most prevalent are the Unruh Civil Rights Act, the Fair Employment and Housing Act, and the Holding Act. So starting from the bottom up, the Holding Act really focuses on lenders. And then the Fair Employment and Housing Act, that creates the Department of Fair Employment and Housing, which is a sister agency of ours. And we work hand in hand with them on discrimination related issues. But the Fair Employment and Housing Act covers all aspects of housing as well as employment and business. But for our purposes, we look at the housing component. And in the Fair Employment and Housing Act, real estate agents, realtors, licensees, brokers, salespeople, they're all defined and encompassed and covered by the act. And same thing for property managers as well. And then moving to the top, the Unruh Civil Rights Act, which has been around, I think, the longest of these 3 acts, that basically talks about housing as well. And so those are the 3 or 5 big acts that really govern this field. There's a lot of smaller acts. But if I can switch to the next screen, I mentioned protected classes or BASICs. So there's about probably a dozen and a half that are set forth in the various statutes. And these come from both the federal and the state laws. And you can see everything from some of the more obvious and the ones that we talk about quite a bit: race, color, religion, sex. And then some of the newer ones that have popped up in recent years: gender identity, gender expression, sources of income. A few of these have been amended as of a couple years ago. For instance, race has been amended to include hair texture and style of the hair. Sources of income has been amended to include subsidies that individuals may have. For instance, if they're going to receive Section 8 vouchers, they can't be discriminated against for bringing that type of revenue stream to the application process. But there's also a handful of additional bases or classes, and these 4 are specifically set out in the Unruh Civil Rights Act. And so these are applicable here in California, and their primary language, immigration status, age, and citizenship. So with that, I just want to go through some numbers just to give you an idea of what we're talking about. So we partner with the Department of Fair Employment and Housing. That department is better positioned to take the lead on discrimination-based cases. They have a greater tool chest. They can act more expeditiously, and they can obtain both civil penalties as well as injunctive type of relief in court. The Department of Real Estate, we focus on our licensees. So in 2019, the Department of Fair Employment and Housing filed a total of 934 cases covering 1,556 bases. And the bases are the areas below that you see, for instance, disability, race. But in the next couple of slides, you can see these numbers broken out a little more specific. But you can see of the 1,556 bases, about a third of them have to do with disability-related claims. So if I switch to the next slide, this is just a breakdown of the prior graph that you saw, giving you some numbers. And then the third slide is a further breakdown of some of those items that fall lower down on the list. And just for comparison purposes, you see that the Department of Fair Employment and Housing in 2019 filed 934 cases. So today, the Department of Real Estate has about 30 active cases right now against licensees for basically housing discrimination related claims. So you can see that the Department of Fair Employment and Housing gets the bulk of the work and takes the lead. We don't see as much of it, but what we do see, we either refer to them, or to the extent that we think we have an actionable case against a licensee, we'll proceed against it at the department level. So here at the department, what governs us is basically Commissioner's Regulation 2780. And this is the regulation that sets forth basically the prohibitions that involving anti or non-discrimination and the protected classes. And the regulation itself was adopted in 1977, and it was last amended in 1980. And you'll see a couple slides down that we're going through a process to amend this regulation to bring in and make it current based on changes that we've seen in the last 2 decades to a number of the federal and state laws. But the regulation itself prohibits discriminatory conduct by real estate licensees based on specific classes. And those classes are the ones that we set forth, or I set forth in the slides a few slides ago. But I want to give you some examples of what the regulation provides. And the regulation has probably 20, 25 subparts. And I'm just highlighting 4 on this slide and probably 4 on the next slide. But the idea is to give you a flavor of what this regulation talks about. But it's basically based on a protected class, refusing to negotiate the sale, rental, or financing of a property, refusing to show or rent or sell or finance a property, steering people away from a particular property or towards a certain property based on a protected class, slow playing, meaning someone with a protected class, you don't process their application or their paperwork as quickly as you would someone without a protected class. These are all examples of things that would violate this regulation and place the licensee in risk of jeopardizing their license status, and would also jeopardize them in violating the various statutes that the Department of Fair Employment and Housing may pursue civilly against the individuals. And here's 3 more examples out of Regulation 2780, just to give you a flavor and idea of what this regulation is. It's pretty expansive. So I mentioned that we're making amendments to the regulation because since 1980, there have been changes to these statutes, and we want to make sure that the current regulation is up to date. So as I flip to the next slide, The amendments to the regulation are going to essentially accomplish these 5 items. First, we're going to update the list of protected classes because certain classes that are in statute today were not in statute 20, 25 years ago. Secondly, we want to clarify a number of ambiguities. Number one, we want to talk about basically that this applies to persons involving physical disabilities. I think it was unclear in the older version of the regulation. Next, we want to talk about that the regulation applies to both individuals as well as classes. So I think there was some ambiguity about whether it applied to classes or was limited only to individuals. So we are cleaning that up, providing clarity there. We also are addressing advertising practices. And you heard in the introduction this morning, John talk about advertising being a big area of concern. We see a lot of concerns related to discrimination, but also in other areas arising out of advertising. So in this regulation, we're trying to address that. And then finally, we're trying to expand the applicability of this regulation to include real estate related services. In addition to, so it basically be providing like listings of available apartments that would fall under this regulation now. So where is the nexus between fair housing and the Department of Real Estate? What we see is it really comes into the broker. In our model, by statute, the broker is responsible for supervising the affairs and the transactions of affiliated salespeople and broker associates. So basically, the broker is the one that's responsible. So even though a salesperson or a broker associate is off doing something, and it turns out that that something is in violation of the real estate law or the discrimination laws for fair housing, that broker could be held responsible. And our law requires that the broker basically provide systems, training, review transactions, and the 2 areas that I would refer you to is Business and Professions Code section 10177H and Commissioner's Regulation 2725. And that sets out basically our jurisdiction and authority to go after the broker, hold that broker responsible. But it's really the broker who we want to work with to make sure that they're educating their sales folks and their broker associates about the requirements of the federal and state laws pertaining to fair housing. So one of the things that has happened in the last few years is we, to get a license, as you all know, you have to have pre-licensure education courses in order to qualify for either the sales license or the broker's license. And then once you get your license, you have to continue with education and take continuing education courses. So what the legislature did in the 2021 legislative session is they passed Senate Bill 263. And this bill basically does a couple things, but it focuses on both statutory pre-license courses, which are those that are required for folks wanting to get a license, as well as continuing education courses, which are those courses that apply to folks that have a license and need to continue or obtain continuing education. And so the changes that the law makes is it basically adds to the real estate practice course a component on implicit bias. And it basically says that impact of implicit bias, explicit bias, and systematic bias on consumers needs to be part of the training or the education. And that this course has to address historical and social impacts of those biases. And it has to take actionable steps to help students recognize and address their own implicit biases. The other thing it does is it modified the course on legal aspects of real estate. And here it added a component for state and federal fair housing laws that apply to the practice of real estate. And it's specifically added, and this is brand new, and I don't know if any other state has a requirement similar to this. I think California may be in the lead on this, but don't quote me on that. But essentially, it now requires that there be an interactive participatory component where the applicant must role play both as a consumer and a real estate professional. So as this bill was making its way through the legislature, it was originally focused on these 2 aspects having to do with these 2 courses. But as the bill evolved, it expanded and other courses got identified in the bill, and it created a lot of ambiguity. And so what ended up happening is we now need Senate Bill 1495, which is in the present legislative session, and it looks like it's making its way through both houses, and it will eventually get to the governor's desk. But it will correct some of the deficiencies and mistakes that the prior bill 263 had. And specifically, it will combine the new fair housing and implicit bias requirements into the real estate course and take it out of the legal aspects course. And the big concern is legal aspects was a course that brokers are required to take, but putting the requirement in there for both salespeople and broker applicants, it was confusing for salespeople who do not need to take legal aspects, but couldn't find the course anywhere else but the legal aspects. So all that is being corrected and changed. And with Senate Bill 1495, the new deadlines for these aspects will kick in on January 1st, 2024. Otherwise, the things that do not change out of SB 263, they will kick in January 1st of 2023. So just keep an eye out as your license expires. If you're an existing licensee, as your license expires, if it expires before January 1st, 2023, you're under the old rules. If it expires after January 1st, 2023, you're under the new rules. And the new rules require the interactive process, training, the implicit bias training. So just as a heads up. And when we talk about implicit bias, I want to touch a little bit on just love letters. This is something that we see quite a bit. And love letters, most of you probably know what love letters are, but for those of you that don't, it's basically an attempt by the buyer to distinguish the buyer in the eyes of the seller and better position the buyer to get the offer and be able to buy and close on the sale. Oftentimes it relies on implicit bias, and a lot of times it could be basically not very harmful, saying, hey, I grew up in the neighborhood and I love this neighborhood. But what's happening is that implicit bias is playing into the seller's head and trying to say, choose me, I stand out because I have a connection, because I grew up in this neighborhood. But what it's doing is it's discriminating against someone who did not grow up in the neighborhood. And so you can see that is sort of an innocuous example, but some very harmful examples could be, hey, I have kids and my kids would love to go to this school, but you're discriminating against families that don't have kids. You can also talk about, I like to go to this church and this church is a particular religion. You're discriminating against folks that don't attend that church or don't share that religious value. So love letters raise basically implicit bias. And I know the California Association of Realtors, as well as the National Association of Realtors, has sent out messaging to their members talking about how basically licensees should not be involved in forwarding love letters to their clients. And if they get love letters, they should tell their seller clients that they're not going to accept them, they're not going to forward them. And if the seller gets them directly, the broker, the listing brokers and sales agents should let the seller know that they shouldn't rely on the love letters in making decisions. What they should rely on are basically the objective factors, which are price and terms, because relying on implicit bias factors could expose the seller and or the listing licensee to violations of the Fair Housing Act. So with that, that closes out my presentation, and I'm available at the end of the presentations to answer any questions that you may have. But thank you very much, everybody. And
Thank you, Stephen.
Stop sharing my slideshow.
Great presentation. I forgot to mention that 3 of us are monitoring the Q&A. And so if you do have a question, please put it in the Q&A. Lori, Laura, and I will go through them. And we probably will have some time towards the end after our last presenter makes their presentation to go over some of these questions. So feel free, if a question comes up, to put it in the Q&A and we'll monitor those. Well, to our next speaker. So a couple of weeks ago, I zoomed in on the California Association of Realtors meeting, and I went to a couple of programs. I went to risk management and I went to our lawyer meeting, legal affairs. And I got to hear our next speaker, Matt Kenefick, and I told my bosses, Laura and Lori, that it's probably one of the best presentations I've ever seen, if not the best, on ADA, and particularly a very touchy issue coming up right now, which is the website issues, but also questions of what does a realtor do when confronted with some type of a disability issue. As you just heard from Steve, disability claims in California, at least at the DFEH, are far outweighing all the other claims, race and sexual orientation. So with that, I asked Matt, and he graciously agreed to give us some of his incredibly valuable time, as the other speakers did. And so, Matt, you are on.
Thank you, John. It's an honor to be here. Yes, John's correct. I'm a lawyer. I practice in private practice. I'm at Jeffer Mangles, Butler and Mitchell. I'm based in their San Francisco office. And my practice area for the last 15 to 20 years has included accessibility, both physical and communicative. But why we're here today, or why I'm here today, is dealing with website accessibility. And this is a very hot trend, and it manifests in a lot of different ways. People have seen thousands of these lawsuits filed each year, both federal and state, all across the country. You may not anticipate it, but when you put your website on for a listing of property in California, somebody in New York could also see it and sue you in New York over either federal, state, or both accessibility laws. So with that, let me share my PowerPoint. There we go. Okay, so that's my intro. So the first slide, quick outline of what we're going to go over. We're going to go quick, so I'll skim over a lot of these slides so we can clean up in Q&A. I'm just going to go over the legal background and then the applicability of the ADA and correlating state laws to website access and some other communicative issues. So first of all, what is the ADA? We're all pretty much familiar, but excuse me, it's worth noting, it is a noble cause. The idea behind the ADA is to allow persons with disabilities to participate in our society. Historically, pre-ADA, we had other statutes that applied, but not comprehensively to public accommodations. ADA has three different, well, it has more than three, but it has three primary titles. One that relates to employment, one that relates to, one title that relates to governmental entities, but the one that I'm focusing on today is Title III, which deals with public accommodation. And so what's a public accommodation under the ADA? Well, a public accommodation is basically something that's open to the public. It's very broadly construed. And we see that, I'll go back to the prior slide because I skipped over one. So a public accommodation, we traditionally think about shopping centers, retail stores, physical items. In fact, that's what the statute contemplates. However, when we first started in 2006 and in 2009, we had a case brought against the retailer Target pertaining to its website, and the Ninth Circuit changed the focus. And the idea was, wait a second, if you have a website that's an extension, an integrated extension of your facility, then that website needs to be accessible as well, because somebody can't go to your store and have the same experience as somebody who can access the website if they can't. So you can imagine there are store location items, there's e-commerce purchasing options, there's gift card or consumer reward options, there are discount codes, all kinds of things that you can get online. And so the Ninth Circuit took it to that trend, and we have seen it since grow to be, like I said, one of the hottest areas. One of the issues is that the ADA requires public accommodations to make reasonable modifications to their policies and practice procedures, very similar to what we see in the fair housing context. But this is the catch-all. This is where we find if there's not an express statutory requirement, either in the Code of Federal Regulations or the United States Code, that the DOJ, Department of Justice, or a private litigant will enforce. So we also see there's a requirement under the ADA that's also germane to website accessibility for the provision of auxiliary aids and services. What this means is a public accommodation has the duty to achieve effective communication with its guests, members, patrons, etc. And so generally speaking, we've thought about this such as if you're a bank customer, you could request Braille statements. You could request at an event a qualified interpreter. Something like this, you could request either an interpreter or real-time captioning for an event like today. That has been extended to communicative access in the website context as well by some courts. So we heard about the Unruh Act. Well, the Unruh Act also applies, to public accommodations. They have a different language for it. They call it a business establishment, which is a broader construction. So the Unruh Act is a little bit more stringent than the ADA in many contexts. First of all a private litigant can do under the ADA is 1, obtain an injunction, 2, obtain their attorney's fees. Now, certainly the Department of Justice can impose fines and penalties, or obtain them through a judicial proceeding, but a private litigant doesn't have that. Juxtapose that against the Unruh Act, which has a minimum statutory damages of $4,000 per incident. Now, you'll see on my slide difficulty, discomfort, or embarrassment, or deterred visit, that these are attempts by the legislature in Senate Bill 1186 to slow down the imposition of these Unruh Act damages. But they only apply difficulty, discomfort, embarrassment. That only applies to physical access. So what does that mean for you as a website operator or somebody who has a website? You'll get claims from plaintiffs who say, look, I went to your website, once a week for the last year. Or I would have went to your website once a week for last year, but for my knowledge of the barriers, that's a deterrent visit. I want $4,000 minimum per visit. There's a case in the Ninth Circuit, the Lentini case, which addresses that, where similar damages were in fact awarded. The $4,000 minimum is a base. I've seen it go as high as $150,000 for one incident. And so the issue is, we can see in certain cases like class actions, where you have multiple people who have visited certain areas, you can see the numbers get very high. I've seen tens of millions of dollars in settlement. I've worked on a class action where the settlement was about 15 million, worked on another one where it was about 40 million. So it can get really high on the Unruh Civil Rights Act. So a violation of under the ADA is incorporated by reference under Civil Code Section 51, Subdivision F, as a violation of the Unruh Act. So you violate the ADA, you violate the Unruh Act. We'll also see the California Disabled Persons Act, which has a $1,000 statutory damages. Obviously it's a lower act. One thing I will mention is this is arcane language. You'll see the term disabled persons. You'll see in some statutory language that the term handicapped. Just for an etiquette issue, generally speaking, the appropriate etiquette is to refer to a person with a disability, person first. There's, the focus is that they're a person, they're not a disabled person. Handicapped is considered a 4-letter word in the accessibility world, based upon a false etymology that refers to somebody holding a cap in their hand. That's not the origin of the term. I've researched it, but still it has that type of stigma. Again, just going on, we see that there are different standards. We see that the Unruh Act just requires limitation on daily life activity, whereas the federal ADA requires a substantial limitation. We see different things. By way of example, California has its own version of Braille. So you could go ahead and buy Braille signage for your public accommodation, and you buy it on a federal standard, and you're not complying with the California standard. So that is a trap. And other states have their own laws as well. New York has both a state and a city level Civil Rights Act. The damages are much smaller, $500 there. So websites. So for websites, one of the biggest challenges is there's a lot of ambiguity as to the standards. But the general guidelines that most people look at are the web content accessibility guidelines, which are put together by the World Wide Web Consortium. Currently, we're on version 2.1. There's A, AA, and AAA success criteria factors. And as you can anticipate, AAA provides the most success or most access, whereas level A provides lesser access. The idea is these are conceptual guidelines. How they're executed and applied is subjective in many respects. The W3C is getting better at what they put out there. They provide more guidance, but for the most part, there is some subjectivity, and that's why there's some challenges on this. We've had the Department of Justice say that they were going to adopt WCAG with an advance notice of proposed rulemaking, which they withdrew the day after Christmas 2017. However, we have consent decrees and enforcement proceedings from Justice saying that WCAG is the standards. We do see amicus briefs from Justice saying that they want people to use WCAG. In the Ninth Circuit, we have a famous case, the Robles versus Domino's Pizza. That case, they said that WCAG nonconformity, while may not be the standard, it absolutely is a manifestation. It can be evidence, circumstantial evidence of a website being not accessible, and the court has the equitable discretion to require you to comply with it. So that's important to think, right? So if people are looking at WCAG, when you work with your developers, you're going to want them to strive to achieve WCAG conformity. We had recently this year, March 18, 2022, we have guidance where Justice has said, look, we believe that websites are public accommodations, and they make a reference to WCAG. So here's an interesting and important part is, so let's just say you fix your website today. It may not stay compliant because just like anything, it requires maintenance, and you're also updating your website. You can imagine if you're a brokerage, you're going to be changing listings on a daily basis, things like that. So it's important to have an infrastructure to ensure that you're compliant tomorrow, not just today. And this is important not just to achieve access, but this is important to protect you from claims. And the reason being is, first of all, just because you fix a website and render the injunctive claims moot, which is a common defense to federal jurisdiction, if you have an infrastructural gap, the plaintiff can say, we're not suing over this website, we're suing over the infrastructure. So it's important. So what does that look like? You have a policy that says, look, we are going to, as an entity, as a business, as a going concern, as an individual, whatever we're doing business as, and having this website, we're going to have the policy that we're going to provide access by conforming with whatever. And like I said, I think WCAG is the appropriate manifestation of that. And you can go online, you'll find all over the internet people who have policies. A lot of them are based on the ones that I drafted, but the ones that I have drafted follow what the Department of Justice asks for in its consent decrees. The idea is you put these policies in place, you train off of it, meaning that you onboard your employees based on it, you put in your employee guide, your handbook, you make sure that it's circulated to your website development team. If they're in-house or out-house, you do that. You want to make sure that if you do have any third-party content procurement guidelines, that this is referenced in it. And again, the idea is you want to show to the outside world or an agency that you have a demonstrated commitment to accommodating persons with disabilities. And one of the things that's important is to have a accommodation or complaint channel. So somebody can make a policy modification request or an accessibility complaint. We usually put it down at the bottom, send it to this person. The person it gets we put it on the tabs on the bottom of the site. If you have any policy modification or accessibility complaints, please contact this person, submit this link, whatever. And the idea, of course, is that that you're going to get that, and that person's going to have ownership of it, and they're going to track, maybe an Excel spreadsheet or something, all the different complaints they get. And when they have none on that spreadsheet, it's a great way of showing that you have no problems with it. It's a great way of proving a negative, which is very important. So moving on. So issues with website access, they're very easy to file. So we see a lot of lawsuits and complaints and demand letters. Keep in mind, not all demand letters turn into lawsuits. So you have to handle that, based on the letter. There's automated testing versus use case testing. So what's that? Automated testing is people use software. Some common software that people use is, by way of example, WebAIM has a WAVE, W-A-V-E tool, free online. A lot of plaintiffs use that to figure out whether or not your site is accessible. But that's just a computer tool that goes to your website. Picks up a lot of false positives and it misses a lot of stuff. You compare that to use case where you actually have persons with disabilities. Try to use assistive technologies on your website. The issue is that automated testing is what most plaintiffs use. So when I work with my developers, if we're only caring about for the specific issue of mitigating or reducing litigation exposure, one of the goals that we do is we say we want to make sure that we get passing scorecards on automated testing. Even if there are false positives, fix the false positives. You don't want to have to pay somebody like me to try to convince a plaintiff's attorney that that this is a false positive. Again, we have the damages issues. We have the issue that websites are difficult to remediate. That also just it pushes these to be very, very common claims. One issue that comes up a lot is people are leaning towards overlays. That's a widget that you can pay $49 a month, like Accessibility, to have them sell you a product that's supposed to interact with your consumers or visitors of your website and fix the gaps in your website. A lot of criticism out there are of these widgets and overlays. Some of the top advocacy groups are against them. They don't believe that they're appropriate. They don't believe that they initiate when you land on them, and they don't believe they achieve access. So that has led to a lot of plaintiffs' firms targeting people who specifically use these overlays. So my advice generally to most of my clients is stay away from these overlays. I know you're going to get a lot of promises from the companies selling you them, saying how wonderful it is and how you're going to be protected from litigation. But in the trenches, and I handle these claims all across the country, and I handle a lot of them, I can tell you that the plaintiff's attorneys, they see you got an overlay, they're targeting you. That's for a lot of reasons. We have websites. If you have video content, keep in mind if somebody is deaf or hard of hearing, they're going to want captions on pre-recorded content or a statement that says there's no sound use in this clip. Again, keep in mind there's a lot of different disabilities. The traditional one that we've seen in website accessibility is people who are blind, who use screen readers, meaning that they tab through it to your website and a technology reads to them the content. But there's other disabilities that are involved as well. We have cognitive disabilities. We have people who are deaf, people who can't use a graphic interface, things like that. This is something I'll skip over real quickly. Just if you're involved in lodging or have any type of lodging involved with your clients, you're required to have reservation systems provided in the same way for persons with disabilities as without. That's important because your website has that. That's a big area of litigation. We have some Department of Justice guidelines and a bunch of case law on that, and it's currently on appeal. So emerging trends, we talked about Justice issuing a couple months ago some guidance saying that public accommodation includes a website and the WCAG is referred to or referenced. So I don't think we're escaping that. We do see that different jurisdictions disagree as to whether a website is a public accommodation versus not. 11th Circuit, we have a trend away from that, but I have seen some recent lawsuits over websites in the 11th Circuit. 3rd Circuit, even though the law is not clear, that's a very popular district, Western District of Pennsylvania. People get dragged there all the time. It's not a good place to be as a defendant. New York, very common, both southern and eastern districts. And then obviously we have the 9th Circuit. Last statistics I saw, about 1/3 of all federal lawsuits filed in the Central District of California, that's basically Los Angeles area, were accessibility lawsuits. So much so that the Los Angeles District Attorney has paired up with the District Attorney's Office from San Francisco to target a particular plaintiff's firm that was filing thousands of these lawsuits. It's not the first time we've seen this. We saw Riverside do the same. We have courts in California affirming damages for website accessibility. I would keep in mind that obviously we have a new administration. The Trump administration was more lenient, but the Biden administration is not. They're more active on enforcing civil rights. Every website, including law firms, are subject to the ADA. Potential solutions: use a website accessibility remediation company. There's companies out there that specialize in website access, but traditionally that used to be the case. However, these days most developers have a pretty good idea about website access. So if you have a developer, have that dialogue, and when you refresh your website, build into the scope of work an accessibility component. We talked about overlays, which are a challenge. It's a good idea to sometimes monitor your website, check it periodically. Maybe build that in your scope of work for your website accessibility, your website development, just to make sure that content that gets uploaded or changed doesn't put you out of compliance. And generally speaking, most accessibility violations do not have insurance coverage under your most general liability policies. It's a lack of an incident or occurrence. It's also lack of a physical injury. And then there is a case out there saying that accessibility violations are intentional violations of law. However, that said, I have obtained for clients coverage under E&O or EPLI coverage. Equally fundamental, there is a product out there that I have seen written, not a great product, but it's an insurance product. It was written by a Lloyd syndicate that would give you about $50,000 worth of coverage. But that's it. Appreciate it.
Thank you, Matt. We've got a lot of questions. So Laura, you and I and Lori monitoring them, you wanted to make a statement about, somebody asked about the slides. Did you want to go ahead and do that now, or did you want to do it later?
Oh, I did put it in chat that everybody who registered for this event will get the slides emailed to them.
Right. And there's a lot of offices that are doing this as an office meeting, so they can distribute it amongst the people that attend their office meeting as well.
There are quite a few questions for Matt on the ADA and the websites and all that.
Yeah, it's consistent with what we're saying. A lot of questions, Matt. So take a little break, get ready, because you'll be coming back real soon. But right now we have, and I'm going to pronounce it again and hopefully do it correctly again. Eva Melgarejo is, thank you. Yes, my Spanish is getting a little stale here in Tennessee, but I still think I got it. So Eva, you're going to let us know about some issues regarding generational wealth building and what the members can do and how they can get some more information. So go ahead, and then we're going to finish up the official presentations with the mothership, the National Association of Realtors report. So go ahead, Eva.
Thank you so much. And thank you so much for the invite. I'm super excited. As a Latina, I'm very, very proud of what my community has accomplished and where we're heading. So this is a blessing for me to be able to speak on this. I would like to start with what is the percentage of homeownership according to the US Census on the last quarter of 2020, so that we can understand what the gap is. So percentage of homeownership, 74.5 whites, 44.1 Blacks, 49.1 Hispanics, and 59.5 Asians. So you can see that there's a huge disparity between homeownership within the white community versus minority groups in general. I'll speak to Latinos and the Blacks just because that's kind of my forte. The number one issue, what is the number one issue? And I think we need to understand the why behind that. Number one issue is going to be credit. The reason why Latinos and Blacks are getting denied applications is credit. The reason behind that, two very different reasons, but at the end of the day, it's education. As Latinos, you have, if I can put it in simple terms, think of it as two buckets of Latinos. You have your Latino generation that migrated to the US that has very little understanding of what credit is, doesn't know how to take care of it. Maybe they think that getting credit is going to the local furniture store and just getting a credit card and maxing that credit card. So we have a lot of misconceptions and just lack of education in those communities. And that is why we end up getting applications denied. We also, as Latinos, love to be of service, and we are in a very close, tight-knit community. So if my mother or my sister or my friend needs me to co-sign for a car, I'm going to do that. So when we run credit as a lender, we run credit, we see what the debts are, and it usually takes them out of that possibility of buying a home. So a lot of it has to do with education, just going back to what is our opportunity. It's not necessarily an obstacle, is what is the opportunity here so that we can get them to that place where they can actually purchase a home. It's very important for the real estate community and also for us as lenders to understand where are these communities positioned at? What is their pain point? Not just speaking Spanish is not going to solve the issue or be able to guide them in the right way. We need to understand what their frame of mind is so that we know how to guide them moving forward. So being bilingual, but being bicultural is going to be eminent. Now, you don't have to speak the language as they do, but you do have to make an attempt to understand where they stand and to meet them at their comfort place. There's a lot of mistrust. If we think of those two buckets that we were just talking about, the Latino millennial who has been raised in the United States has a very different experience than the immigrant community. So understanding who you're talking to, what their pain points are, and how to gain their trust is going to be basic. Let's talk about, well, I'm sure that you think that this is a handful, right? Why should we go after the Latino community when they need so much hand-holding? Let me tell you, Latinos are aging into prime home buying years. And I was reading a statistic. The median age of Latinos is 30 years old. 2 in 3 Latinos are age 40 or younger. So they're the ones buying houses. They are going to be the majority of those first-time homeowners that you're going to come across. Now, the millennials, this is very interesting. Millennials are buying at a younger age. According to Realtor.com, there's a really cool statistic. 34% of new Latino homeowners are buying between the ages of 18 to 24 versus 17% of the general population. So you're seeing this Latino household buying not just for themselves, but also being the one that buys for their parents. Understanding the millennial Latino and understanding the immigrant Latino is going to be key. Let's see, we have something else. How do you prepare for them? We talked a little bit about being bilingual and being bicultural, not just talking the language, but also understanding that they don't trust banks. Your immigrant Latino is not going to trust the bank system because they didn't grow up with it, versus your millennial Latino who has been raised in the system and understands credit. So you have mom and dad and you have son or daughter, who are all going to be involved in that transaction. Make sure you understand that those cultural differences and that you meet them at their comfort zone. I cannot stress that enough, because a lot of the time your millennial Latino is going to be okay doing a Zoom call, but your mom and dad are going to want to meet you. So think of, in simple terms, think of what are those home buying preferences. If you know that the millennial is going to go online, make sure you have online presence. If you know that your Gen X generation is going to want to touch and feel, be ready to meet with them. It may be at the local Starbucks, it may be at their home. So understand those nuances of the cultural differences. Be sure to have a team that is going to support you, not just speaking Spanish and not just your lender, but also the team behind them. I can't tell you the number of times that I've had my processor contact the actual buyer in Spanish, in their language, be able to communicate and be clear on what's happening and what the process is. So your team behind you has to have the same commitment as you do. Your lender, let's just talk about the issue with credit. You want to make sure that your lender is able to do rapid rescores, that they're able to understand what are the issues on this credit report, and can we build a program or a roadmap to take them into homeownership maybe 6 months down the line, maybe 12 months down the line. Are they committed, just as committed as you are to this community? You have to have the right resources in place when it comes to the programs that they're going to need. You have I-10 borrowers in the Latino market. I-10 borrowers are going to need a very special program. We have a 15% down payment. There's a 20%, 25% down payment. So just make sure that your lender is able to satisfy the needs for your I-10 borrower, for your bank statement loans, your 1-year tax returns, because the other part is your Latino immigrant most likely is going to be self-entrepreneurial, meaning they're going to have their own business. They're going to do things their own way. So you need to make sure that your lender is able to provide them with the right programs. Going back to the issue of credit, do you have somebody in your, I was going to say Rolodex, that's just aging me, but do you have somebody on your speed dial on your phone that is dealing with credit, and can they educate them on that? So that's really, really important, meeting their needs where they're at. Now, how do you capture them? Going back to being bilingual and bicultural, but also host classes, bring in the experts. You may want to do a Zoom class and talk about credit. You may want to do a first-time home buyer seminar that is in a physical location so that they can drive over. Think of the content that you're pushing out on all of your social media platforms, because maybe the mom and the dad may not look you up, but the daughter or the son who are going to be translating for them and who may be part of the loan will. So make sure that you are a resource and you're coming from a place of assistance, and that will get you their trust. One more thing, understand that this millennial generation is, or the Latino generation, whether it's the millennial or the immigrant community, home ownership for them is not just the dream of the American dream, the one that they came to the United States for. Home ownership for them is going to be a legacy. Unfortunately, we don't have the decades or the centuries of living in the US where we already have the generational wealth. We are in the process of building them. So I'm going to tell you why it's also important that you really embrace this community. 17% of millennials are Latinos. Your next generation is Gen Z. 25% of that generation is going to be Latino. So this is your next home buying community that's going to come to you. You want to know where they're coming from. So don't embrace them. Do embrace them. Don't ignore them, and nurture them. And I'm here for questions or anything that you may have at the end of the presentation.
Thank you, Eva. I know that when my grandparents came here from Italy, because it's a different kind of a culture, immediately they built their wealth by buying real estate, and that generational wealth was then passed on to my parents, and it created something that allowed us early access into what you refer to as the American dream. So I think what you're doing is phenomenal. Really appreciate it. And yes, there will be questions. I know, because I wrote 2 of them down myself.
Great. I can't wait.
All right. So for right now, we got, we're going to hear from the mothership. National Association of Realtors has been doing some incredible things with fair housing and diversity and all of the rest of it. And rather than hearing from me about it, Mike, I'd like to have you tell us some stuff that's going on at NAR, what we might anticipate. I know you're going to zero in on 2 really hot button topics, advertising and disparate impact. And then once all that's done, then we'll open it up for some questions, and we'll do that in just as soon as you're done. So have at it. There's no time limit. Enjoy, Mike.
All right, thank you so much, John. And yes, as John mentioned at the end of my presentation, I'll share some resources we have just in a broad fair housing context. But let me try to share my screen here. Hopefully I can do this properly. And also please let me know if there's any issues hearing me. Okay, can you all see that? All right. So as John said, my name is Mike Rohde, staff attorney here with National Association of Realtors. Thank you so much for this opportunity to speak on these fair housing sort of legal issues. And you know, Steve had mentioned, and obviously Eva and Matt had mentioned also, you know, fair housing and compliance with fair housing laws. It's kind of the minimum, which, you know, obviously that's important to do. But I think, as we've all kind of emphasized here, we want to take it a step further. I don't think it's controversial to say that there's more that we can do. And so, you know, today I'm hoping to share some practical tips, guidance, rules of thumb, if you will. 2 main areas: advertising, and that's both the when you're crafting ads for available properties, and then also when you're crafting ads for your real estate services. I'm going to cover both those topics, and then also disparate impact, which are, you know, practices or policies that might disproportionately affect a group, you know, defined by these protected characteristics. And so, you know, I hope to explain some of these concepts, and then provide some examples, some case examples, and then also some best practices. So one thing I do want to share is, you know, in fair housing, there's a lot of gray area. It's not always sort of this, you know, black and white on what's discriminatory and what's not. And so I want to share that it's really important to remember that even defending an allegation or even defending a claim can be very time consuming, can be very resource consuming. And so if you're sort of operating in this gray area where, you know, it's something, a little voice in your ear saying, hey, you know, this could be potentially a violation of fair housing, it's probably best to fix it now, because, you know, there's reputational issues that could come about if you have to defend these claims, and then just the expense. And also your liability insurance policies. Fair housing and discrimination claims aren't always covered by these liability policies. So it's always good to do maybe an audit. There's obviously endorsements out there to make sure you're covered. But you know, paying out a settlement, paying out a fine, these can be obviously expensive, time consuming. And so you know, that's why, you know, it's always important to be compliant in these fair housing issues. You know, this is probably a review here. You know, Article 10 of our Code of Ethics is, you know, the Fair Housing Act. And then, you know, as Stephen mentioned, the Fair Employment and Housing Act in California. You know, these goals are encompassed in Article 10, these duties we all have as realtors, you know, within Article 10 of the Code of Ethics that requires all realtors to provide equal professional services and to provide discrimination and to avoid discrimination regardless of an individual's inclusion in a protected category. And, you know, Eva touched on this, you know, these home ownership rates. I'm so glad she did. You know, this quick graph, it's available on our website. I think it's very impactful to see this between 2010 and 2020, when arguably, I think nationwide, the housing market was kind of in a growing, you know, sort of boom market. You look at the homeownership rate of whites, Asians, and Hispanics all went up in this period, while African-American homeownership rates fell. And remarkably, if you look at in 2019, the gap in home ownership rates between white and African Americans was actually larger than it was over 50 years ago when the Fair Housing Act was signed. And so I always think it's important to remember the why. I mean, obviously we want to be compliant with the law, but the impact in communities and how we can sort of bridge the gap is really important. And so that's why we emphasize our commitment to fair housing. And quickly, just on a personal level, prior to coming to NAR, I did a lot of legal work for a public school organization that we did work in Chicago and Detroit, in the inner cities of Chicago and Detroit. And one of these sort of indirect impacts we saw on children, on students, was this idea of instability, of sort of a transient nature of students. They might go to a new school every year, which right then and there, you think of, stability. I was lucky enough, I went to a school, all kindergarten through 8th grade, for example. Well, if families are moving around, if there's instability with housing, which home ownership can solve, you see less and less students who are going to a new school, which makes it easier for them to ingrain themselves in the community, which helps the staff and the teachers know how they learn. And so, just think about all the impacts of fair housing. And I'm kind of going down a rabbit hole here personally, but this graph, I think, is very, very impactful on the more work that needs to be done, I guess. And so quick also review here. I know Steve covered it. Federal Fair Housing Act, and then also California's Fair Employment Housing Act prohibits discrimination in all aspects. And I've highlighted all aspects there because advertising is covered. New York Times, magazines, newspapers, they've all been sued under the Fair Housing Act. And so all aspects related to housing is covered. And you see the list of the categories which Steve went over. I know California, the list is much more expansive: source of income, immigration status, marital status, among others. Steve's definitely probably more of an expert on that list than I am in California, but just quick review there on the Federal Fair Housing Act. And so when you think about advertising, let's talk about advertising available properties, and then also advertising your real estate services. I'm going to cover those two areas, and then also the evolving landscape of what's interpreted as a violation, a problematic area. Over time, our culture evolves, and what's considered maybe not a violation previously, decades ago, might be considered now a violation. And so it's always important to consider the evolving landscape in fair housing with advertising. Quickly, so some very general rules of thumb when you're making choices in crafting your advertisements. These 3 rules of thumb. First, focus on the property, not who might be the ideal resident. Ads invite litigation and complaints that might mention who might be a perfect fit for a property, perhaps students near a college campus, families, perhaps a certain racial demographic. It's always best to avoid those and just focus on the features of the property. Just to kind of illustrate that, if a listing emphasizes the proximity to, let's say, an ethnic or religious landmark, a church, synagogue, this could be perceived as focusing that ad toward a particular group and could invite some of these issues, a complaint, potential violation. And again, when marketing your professional services, a main point of emphasis we try to always hammer home is to avoid implying a preference toward a particular group that you might try to be providing those services to. And then also, you want to avoid discouraging any particular groups from answering the ad. An example of this is when using human models. It's human models in advertisements. We see them all the time. Both HUD and the courts have made clear that human models should reasonably represent the demographics of the groups in your particular market. And context is very important. It's, one ad isn't going to be make it or break it for a fair housing violation. You look at the whole context, but again, just sort of a rule of thumb when you're making decisions on your advertisements. So up here, you see these 7 sort of pink colored circles here. I'm very proud of this slide, how it came out. So you have 7 examples of sort of common phrases you'll see in listings. And then the next slide, you're gonna see these are going to fade into either red or green. Red being, probably something should be avoided, and green being, well, probably not necessarily problematic of a phrase. And so I don't know if you want to quiz yourself, but here we go. I'm gonna see. Hopefully this works okay. All right, there they go. So as you see here, I'll kind of walk through them really quick. So starting on the top left, short walk to public transportation. This, is an argument. This could imply an exclusion of handicapped individuals, but this type of phrase also, the phrase walk-in closet or, balcony has a beautiful view. These might imply some sort of exclusion of handicapped individuals, but HUD has provided guidance that an ordinary reader, sort of the reasonable person would not find these to be discriminatory. One quick note on, individuals with disabilities, you could affirmatively market a property's features to people with disabilities, such as, it has a ramp or an elevator, sort of a lift. While that could be perceived as targeting groups with disabilities, affirmatively marketing a property's features in that regard is not considered, probably would not be considered a violation. So then moving along, beautiful Mexican tile. Another example of this, traditional African architecture or Asian doors, characteristics, these probably wouldn't be considered to be problematic phrases because it reasonably describes a property's features. Even though there's reference to nationality, a demographic, these probably wouldn't be considered violations. Then moving on, perfect for students, in the red, first red one. That's probably a little problematic because that sort of implies an exclusion towards people with families, maybe individuals with advanced age. There is an exception. You could market a property as being housing for older persons, for example. There's, if the property qualifies in the Fair Housing Act's exemption with the, under the statute. So you could make it toward housing for older persons, but probably want to avoid, targeting, say, perfect for students, young people, single, what have you. Moving on then, specialize in serving Polish-speaking homebuyers. So this one, is a little problematic because that indicates a preference toward a demographic that you might be seeking to serve. What's a better option there below it, that your office offers a wide range of translation services. That's an inclusionary statement. Services that your office provides, probably a little better choice there. On the other left, they're located in the heart of Chinatown. So that's probably not problematic because, referencing, Chinatown, Koreatown. Here in Chicago, we have Ukrainian Village, Little Italy is another example. These are formally recognized communities, and that's a question from there is, well, what qualifies as a formally recognized community? And I think for me, quick reference Google Maps, and if you search, hey, where is Ukrainian Village, or where is Chinatown, where is Koreatown? If it comes up as recognized and it has a little border there in Google Maps, it's probably formally recognized. If you're advertising a property, it's maybe with using these sort of communities and these sort of ethnic based titles of the communities, it's probably best to include equal opportunity housing for all type message, just as a best practice. And then finally, that red one there in the lower middle, referencing schools and school performance. This is a topic of caution, kind of at the national level. It's sort of become sort of an implied indirect redlining. if you're comparing two school districts, you could, we'd probably caution against it, but you could reference that a school district is well performing, that the home or the building is located in a well performing school district, but you should definitely have an objective basis for making that claim. But it's, again, referencing schools, high caution with that. And, you can always direct your clients to, websites that have school rankings and have them, do their own research. But those are just some examples for advertisements. And so really quick, the ordinary reader standard. So courts will use this, they call it the ordinary reader standard when they're evaluating ads in the fair housing context. It's similar to, I mentioned reasonable person, sort of this, who is the average individual and how would they view an ad in a fair housing sort of discriminatory context. It's important to note there, the second bullet, that, intent is not really, having a discriminatory intent is not necessary. They don't look at the intent of the author. Instead, they focus on the effect on the audience. And so, it's not a very good defense to say, well, I wasn't trying to be discriminatory. So it's important to remember that. And then, moving down that quote there, that this ordinary reader is not, let's say, the most sensitive person. It's not the most woke person, right? There's a relatively famous case in the late 80s, Reagan versus New York Times, that involved allegations against the New York Times that all of their home available housing ads only featured white people, and African-American models were always just represented as, say, maintenance workers. And in the opinion from the Second Circuit, they said that, discriminatory messages don't have to be, let's say, like a swastika or a burning cross, but the standard is, would this ad discourage an ordinary reader of a particular race from answering? And so that's kind of the context you have to look at this ordinary reader standard. The totality of context is also important. There's a famous case in the early 2000s in California with Donald Sterling, and Donald Sterling, who had many apartment buildings, would use the Korean flag in announcements of available apartments, and would name his buildings with the word Korea in the name of the buildings. And so he had there was a lawsuit and ultimate opinion about the use of sort of this nationalities in the titles of buildings and in advertising. And so the context is very important. So the fluid nature of the ordinary reader standard is kind of important. Sensitivities evolve over time. It kind of goes both ways. 3 examples on this. The Confederate flag, probably 25 years ago, if you have a listing, a photo that had the Confederate flag, it probably wouldn't, cause much of a controversy or invite a complaint. However, now we at NAR definitely recommend not using the Confederate flag, strongly recommend not using the Confederate flag in any of your housing. And I know that's probably well known to everybody on this, in this Zoom. Another example of kind of going the opposite way is the terms exclusive, traditional, restricted. Back maybe 40, 50 years ago, these terms were used to sort of imply, certain members of a religion were not invited, or race were not invited, or there was restrictions against who could apply for housing or purchase a home. Well, now, fortunately, those are all relics of the past. And so using a term exclusive, if you're describing a neighborhood, or restricted, those aren't as problematic now, because that just might be describing the neighborhood or referencing the part of town. And so, and then finally, the last example, master bedroom, right? 25 years ago, master bedroom, very common phrase. It's still a common phrase in NAR. I'm not here saying that it's now something that we shouldn't use, but there's definitely some discomfort when it comes to master bedroom, of the obvious connotations to slavery. And so my point is that, these sort of what's considered problematic and what's not. It evolves over time. Private lists, just a quick word on those. There's a lot of lists out there that might say, hey, this is the official list of what's acceptable or unacceptable words to use in listings. HUD or any other, official federal regulatory agency, as far as I'm concerned, that I'm aware of, hasn't produced or endorsed an official list. And so, these can be contradictory. So just use caution and remember that courts will analyze the whole context of an ad. And so, so moving on to disparate impact. And so sort of the definition there of disparate impact is, it's best understood. It's a method of proving housing discrimination without having to show that discrimination was intentional. Some quick points on that. In 2015, the Inclusive Communities case, it finally affirmed in the United States Supreme Court that you can assign liability under the Fair Housing Act for practices that disproportionately affect individuals in a protected class. There was a circuit split before that, but that proved that, disparate impact, there's liability under fair housing. So to prove disparate impact, first, a plaintiff must show that a policy or practice has caused or predictably will cause a discriminatory effect. And if they can prove this, through statistics, through examples, the defendant, then it shifts to the defendant to show that whether, the practice or policy is necessary to achieve a substantial, legitimate, non-discriminatory business interest. And now I'll get into an example. Criminal background checks that's been referenced on this call is probably the most common example. And then finally, a plaintiff could still prevail even if a showing of a substantial, legitimate business interest is shown. The plaintiff could still prevail by showing that the business interest could be achieved by a less discriminatory alternative. And so getting into some examples, the criminal record screening is probably the most important one. African Americans and Hispanic people have disproportionately higher arrest rates and criminal record rates. Therefore, a blanket policy that would deny applicants based on an arrest record or a denial based on a conviction with sort of no connection to a legitimate non-discriminatory business interest is probably definitely going to be a violation of the Fair Housing Act. Other examples would include occupancy laws, practices limiting children, limiting the number of unrelated occupants in a home or a dwelling could be a violation for family status. Also prerequisites, having to show full-time employment, a credit check, having to show pre-approval, and then also sort of there's governmental zoning practices that have been challenged, practices that eliminate affordable housing and that sort of perpetuate redlining are other examples. And I know California, Steve touched on the code of regulations. They make it very clear in California that it's unlawful to take adverse action based on an arrest record or a sealed conviction, juvenile records. It's also unlawful in California if you have a blanket policy denying all applicants with a criminal record or a conviction without consideration of whether that conviction is directly related to a risk posed by the home that the individual is trying to occupy. And then also very recently, in February of this year, there's a new assembly bill. I don't think Steve mentioned it, and I hope my research is accurate. California bill, Assembly Bill 2383, which would basically implement a procedure where if a landlord denies an applicant based on results of a criminal background check, this law would allow the applicant the opportunity to respond and explain, well, this conviction was from many years ago and I've been rehabilitated. And so you can respond with mitigating factors. Ultimately, then the owner or the landlord making the decision, they would be required to reconsider using this mitigating information, but ultimately, and they'd also have to provide a written decision to the applicant. This law, this sort of procedure that would be required on a criminal background check for housing. There's a similar law in Illinois with employment. And so I don't know if that's where they got it from, but we'll see. It's just interesting. I noticed it is just recently introduced and is undergoing some debate probably in the legislature as we speak. Lawsuit, and just a quick example of a lawsuit that was filed last week against Safe Rent. It was a class action lawsuit filed against Safe Rent, which is a software provider that assigns applicants scores, and these scores purportedly measure an applicant's quote lease performance risk, and so this lawsuit alleges disparate impact against a disparate impact against African Americans and Hispanic consumers because the algorithm does not consider housing vouchers. And so having this software, if it's used by landlords in determining who can rent the properties, they're arguing it's a disparate impact. Again, it was filed last week. So, just an example that these are still very relevant and we'll see them to come, I'm sure. Okay, so finally, just kind of wrapping up, I promise, John, I'm wrapping up here. The best practices. So, we talked about earlier, focus on the property, not the ideal resident. Pretty simple. Again, just a baseline best practice. You want to avoid, mentioning those you wish to serve if you're crafting your ads for professional services. If you have policies or practices involving criminal history background checks, consider mitigating factors, time, severity. Having just a blanket policy is probably going to be problematic, and especially if it's exclusionary. And then finally, kind of the golden rule, treat all fairly and consistently. And some of these require some critical thinking. And so it's always important to do an audit, self-review, really to sort of wrap up here, I need to plug our resources at the National Association of Realtors. We have a newly revamped fair housing page. It's kind of a one-stop shop for resources. You find the latest news, information, videos, resources. And then really quick, this is really, it hasn't been announced yet, but we're creating a program. It's in the pilot testing phase right now. We're creating a program for brokerages who want to voluntarily test themselves for discrimination. I think we're all aware of the Long Island news feature from 2019 that exposed, wide range steering and other discriminatory practices. Well, at NAR, we're in the works to develop this sort of self-testing program. And so if you're a brokerage, you could work with us to do confidential testing. And you want to maybe do this with us before a newspaper or a private fair housing group does. And so your agents, your licensees could be tested. And then as a brokerage, you could receive a confidential report of the findings, which then might trigger, additional training or other remediation measures. If any problems are uncovered. And again, like I said, a pilot is underway, and be happy to kind of share or if anybody is interested in participating. And then also really quick, in November of 2020, we launched Fairhaven. I'm sure maybe some of you have participated. It's a simulation. It's almost like a computer game that uses the power of storytelling to help members identify, prevent, and address discriminatory practices in real estate. And it's inspired by real stories. It's innovative. You work against the clock to sell homes in this fictional Fairhaven. And so it's an interesting kind of you get to walk in the shoes of a home buyer facing discrimination. And so provides feedback, and we encourage all members to visit fairhaven.realtor to get started. And then finally, thank you so much for taking the time to listen. John, Lori, appreciate it. Happy to obviously answer any questions, and hope I didn't take up too much time. It's lunchtime for me here soon, maybe you all in California and the West Coast as well. So I will hopefully figure out how to stop sharing my screen here. And that concludes it for me. Thank you.
Those were some incredible presentations. I'm just so amazed at the quality and the insight that all of you have. And yes, there are some questions. I know, Lori, you've got some on the Q&A. I saw someone raise their hand. I've got a couple of questions that came in before we went on today from some brokerages. So if I can just add, while you're organizing the questions you want to have the speakers ask, if I could throw one question to each speaker. Matt, I'm going to start with you, something that came in, and I think you and I might have even touched on it when we spoke. And that's people are asking, so I'm having an open house, or I'm going to be taking someone to a showing. And unbeknownst to me, the person has some form of a disability. It could be a person confined to a wheelchair. It could be someone who's blind and wants to be able to read the materials that I'm going to have available. What do I do? What's some tips that I can use to make sure that I'm treating everyone fairly and equally?
Yeah, so that's kind of a law school exam there. There's a lot of issues that are invoked in that. So the practical answer is you're not going to have to, if you, let's say you have an open house, you're talking about physical access. You know, there's different types of disabilities out there, and physical access, let's say somebody requires a wheelchair for mobility purposes. You're not going to have to tear down that house and rebuild it with, with accessible ramps. However, if somebody were to make a request, a reasonable request with a reasonable notice, you have to agree with that and work with that. So I could see that manifesting like possibly in the way of providing a portable ramp if somebody needs that to get in and out of the house, by way of example. We see that a lot. I had a series of lawsuits in Southampton, New York, where all the retail facilities were built up on bricks, right? They were like the foundations were raised for drainage purposes and flooding purposes, snow, etc. And so the whole group got hit by these physical access lawsuits. How do you get in and out of these places? Well, the ADA, first of all, for pre-existing facilities, there's no liability for building the facility wrong. You only have to do reasonable modifications, right? And so those reasonable modifications to your facility, they only have to be readily achievable, and that doesn't mean fundamentally altering it, things like that. But a reasonable modification could be, if you're a broker or an agent, somebody contacts you ahead of time. Reasonable, right? If they show up and they haven't given you notice, that's not reasonable. They contact you ahead of time and say, hey, look, I might come by and look at this house. Can you tell me a little about the accessible features? I think that's reasonable. Can you tell me whether or not it's wheelchair accessible? You can certainly say, I don't know, but there are some steps. And if they say, well, we'd like you to get a portable ramp for me, you might want to do that. Usually with the portable ramps, one concern that we have is safety, right? You don't want other people tripping or falling. So you have to make sure that's done. With regard to marketing materials, we talked about the website, right? The website is a marketing material that needs to be compliant. But if there's handouts or brochures, we have that achieving effective communication. Now, that's an auxiliary aids and services. So for a public accommodation, the public accommodation has the ability to choose which way to achieve effective communication. Other titles of the ADA, you're supposed to give a great preference to the requested form. But you could imagine a situation where you have the exact same information on the website. You could say, well, use the website, that's accessible. Or in the rare event that somebody says, I want I would like to have a Braille brochure. I can't imagine that happening, but you could probably do a one-off Braille print. Like I said, I don't. Braille's very, very rarely used these days. We had a Braille gift. We had 350 Braille gift card class actions in New York. I think I handled 5 of those, and very rare. Braille users are generally speaking, given today's assistive technologies, are very rare. So there's a lot of converging issues there. Most of it's common sense. Again, it's you're not going to have to tear down your seller's home or make changes to it. You're selling a product as is. It's just if somebody's asking for some modifications that are reasonable, I think you have to do it, at least from the ADA front. I mean, there certainly could be other aspects, from regulatory aspects as well.
All right, and Steve, so I've gone to the Association of Realtors and I've been found to be guilty of a discriminatory act, either hate speech or more likely something else within Article 10. And the panel found that my conduct was intentional, and the board of directors affirmed it. I was fined on other things, but under NAR policy, we're required to report that to the Department of Real Estate or any licensing agency, depending upon the state. So what happens when you guys get something where a real estate association has already vetted out and found the person guilty of some type of a discriminatory act and has reported that conduct to you?
Sure, let me see if I can address that. Essentially, the Department of Real Estate doesn't, and we don't have jurisdiction over ethics. Ethics are typically handled by the associations themselves, but we do learn of quite a few ethical violations that may cross over into actual discriminatory practices or other statutory violations. So we will independently look at it and investigate it. If it seems to be a true discriminatory practice, we'll probably refer that over to our friends at the Department of Fair Employment and Housing and coordinate and collaborate with them. We'll look at the licensing side of it. They'll look at it from all other aspects. And so we look at it to see, exactly what was the offending conduct. Did it violate the real estate law? And the real estate law now has basically a reach to discriminatory practices under the various laws that I talked about in my presentation, both the federal and the state. So we could use that as a basis to take disciplinary action, but we will look at it independently. We'll assess it whether or not it's something that we feel is worthwhile. And we'll also look at it from an evidentiary standpoint. Do we have enough evidence for us to move forward before an administrative law judge and argue to that judge that this license should be disciplined? If that's the case, we probably would go forward. If it's strong enough, we would go forward. Independent of what the Department of Fair Employment and Housing does in their arena, we'd go forward in our arena on the license action. So I hope that answers the question. I was just going to make one more comment. I know Mike raised Assembly Bill 2383 as part of his comments. That's the bill that had to do with basically conviction history in the rental process. So he's absolutely right. There is a bill making its way through the legislature right now. It passed out of all the committees and floor of the first house, meaning the Assembly. It's now sitting and making its way through the second house, which is the state Senate. And one additional thing that I want to add, Mike, I think did a good overview of it, but it does set up a sequencing requirement. So basically now in the interview process for applicants, the initial interview, the initial assessment evaluation cannot, if this bill goes into effect, would not be able to take into account criminal histories. That would come in later down in the second or third phases of an application process. And so that is a big fundamental change that basically property managers, licensees who are working with property managers should be aware of if Assembly Bill 2383 takes effect. And right now it looks like it's making that way. It received very little opposition in the Assembly, and I anticipate it will receive very little opposition in the state Senate as well.
All right, and well, I have questions too, but I'm going to be quiet for a second, and I'm going to see what Laura's got cooking, or Lori, in terms of what the people that are here today want to ask questions about.
So I'm going to start with Matt, because there's quite a few questions about the websites when you were doing your presentation. The first one is, are they targeting bigger corporations, or are they really targeting smaller boutique agencies for ADA compliance on websites?
Yeah, so the unfortunate news is different types of plaintiffs target different types of people. A lot of the most common lawsuits are against small companies and small individuals because they don't have the financial ability to defend themselves. So they settle quickly. The large companies I work for, the Fortune 100 companies and banks and all that I work for, we pay less than anybody else does if we do settle the cases because we have the resources to defend. So in fact, we even saw right after COVID hit, we saw a huge spike in physical access cases against small restaurants and businesses. Why? Because the plaintiffs bar knew that these people were hurting so badly that they couldn't afford to hire somebody like me to respond to the lawsuit. So they just paid whatever they could to get rid of it. So yes, small businesses are hit. One of the trends we do see is there'll be an industry hit, right? So cosmetics get hit all at once. Bikes shops get hit all at once. We had plastic surgeons all get hit all at once. A lot of them use very similar website developers, so it's really easy to find common issues with them. So so you can absolutely imagine that there'll be a wave hitting at the same time. And if you're a small business, unfortunately, you are in the lane of fire.
Okay, thank you. What are the resources available for making a website ADA accessible?
Yeah, why don't I, on that one, I'm going to share my screen just to make this a little bit quicker if that's possible. So let me see which screen 3. Okay, can everybody see this? All right. So first, how do you check your web? Froze. Okay, there we go. So I think you can see this. So, I apologize. Can you guys hear me okay?
Yeah.
Yes.
Okay, sorry about that. My computer froze up for a second there. So first we have, here's a way you can test your website, automated. This is a very common tool that plaintiffs use. It's from Wave, or it's a Wave tool from WebAIM. You can see you just type in your URL. And let's just say we're going to type in the Yahoo website. Oh, sorry. There we go. And it's going to run a quick little automated report. And it's going to tell us that we have missing alternate text, 12 errors, tells you where they're at, and it'll go through that. I'll give you a quick little, this is a good little resource. And again, this is one of these automated tests we think you should, at least in my opinion, even if, let's just say this ARIA menu link is broken, I'd still fix it. Now, if you're a little bit more advanced user, you could have the plugin. And the plugin would be, by way of example, it's a Wave plugin, and just ran a quick little report for you. Now, if you're even a little bit more advanced user, one of my favorite tools out there, these are all free tools, is from DayQ, that's DEQUE, and it's their AXE. So we just hit, the development tab here, go, we go to this, and this will just run a quick little report for free. And again, for those of us who do our own programming, or if you want to go over the issues with a more comprehensive basis, you'll see this will give us all these different issues. So, okay, we have 95 errors. Let's look at the color contrast. It'll give us each one. Say, all right, here's the element location, the element source. This way you fix it. Here's the WCAG. So we see it hits WCAG 2 AA level under section 1.4.3. And then finally, if you go to the W3C, that's the agency that the private agency that promulgates the web content accessibility guidelines. It goes through here and it gives you some resources, some introductions, some supporting materials to give you a good way of figuring out what the playing field is. So I hope that's helpful.
It does, and it actually answers the second question. So I'm going to get rid of that one. Would the website accessibility requirement also apply to a private HOA website?
So that's a good question. So HOAs have been held to be public accommodations. So that is an issue. And we do know that there's one plaintiffs group that goes around targeting, has a hybrid lawsuit out there that targets housing, both under ADA and fair housing. say, look, I'm a prospective, either purchaser of a facility here, etc. I want to buy a home. I want to rent an apartment. I went to your website, tried to find out about the facility. I wasn't provided access to it. So I definitely think you're still in the line of fire on that. There are ways of fixing that, right? Where, you completely lock out, people, from the rest of the world from accessing it. But, and you could even, but HOAs have been held to be a public accommodation. And there is also a fair housing component in it as well that overlaps. So I would endeavor to have your HOA website conform to WCAG. Again, it's a cost benefit analysis. The reality is these lawsuits, I usually tell people to reserve about $25,000 if you're going to settle the case. That's settlement value and also legal fees. But it may not make sense. You may have a website that it's going to cost $100,000 to fix. If you're not getting these claims every day, you may not want to do it. Personally, I think it's a better practice to achieve access. Because the last thing you want to do is have somebody with a disability not be able to use your public accommodation.
Okay, thank you.
Or can I jump in?
Sure, absolutely.
Again, because people knew I was going to be posting this, and so the brokers were asking me questions basically to get some free legal advice from these guys. So Mike, and Steve too, to a certain extent. So I'm a realtor, and it's all well and good to talk about, I don't say this and I don't advertise that, but my clients are going to ask, how are the schools? I know that here where I live in Williamson County, it's a big selling feature because the schools perform at a very, very high level. So in terms of a question, regarding something that would be problematic, how do you respond if you've got any information or advice? And then from Steve's standpoint, how do I steer clear of getting accused of something that might end up putting me in front of an administrative law judge?
Yeah, sure, John. It's a really good question. I'd say first and foremost, when you're first starting a relationship with a client, I think it's very important to explain your commitment to fair housing and some of the principles of fair housing, what's potentially problematic, what you can share, what you can't, and then it's a tough balance, right? You want to provide the best services for your client. You want to have a great relationship with the client. You want to close a deal with the client, right? And so it's a tough balance between all of those interests and then your fair housing interests. If you get problematic questions, if you get sort of topics of discussion that sort of trigger these thoughts that we've all talked about today, I would say communicate. I'm sorry, I can't provide that based on that would be a violation of fair housing. I can direct you, I can share with you, here are some resources that explain schools. Here are some resources that might explain some of your questions, and allow them to provide research. Hey, the internet's a wonderful tool for that, right? And then also, if you're having these difficult conversations with clients, I would say it's always best to document, right? To write down, make a record in writing, write an email to yourself, whatever it might be, to explain, okay, we had this conversation, here's the topics, here was the back and forth. You can obviously hopefully rely on more experienced brokers to provide advice and potentially give you some tips when these conversations come up. But I hope that kind of answers the question. It's case by case. These are tough conversations, but I would say to always explain your commitment to fair housing, explain what you can and cannot discuss. You can't steer, you can't explain racial demographics of a particular neighborhood, that sort of thing. And then remember to document. And in some cases, if it gets really bad, if you're representing a seller, let's say, and they are just dead set on not selling to a particular group or something, you might have to sever the relationship, because ultimately, if if you are sort of compliant with their wishes and what they're trying to do, ultimately you could end up being, brought in with them. You're their real estate professional. You could be brought in with them on a complaint that maybe Steve will sort of touch on. And so you'll be sort of tied to the hip with whatever action or practice coincides. So that's kind of, those are my answers with that. It's very tough. It's very difficult. A lot of times you become friends with your clients. I understand that. So, but ultimately, your license could be on the line. Your membership with NAR or local association could be on the line. So it's important to steer clear as best as possible.
Steve, anything to add to that before?
If I would just add, there's a few buckets. You separate the buyers from the seller side of the coin. So, if the buyer is asking, or prospective buyer is asking his or her agent some reasonably objective type of questions, like, where are the schools nearby, things like that, it's probably safer, or safe to answer. Certainly the safest approach is, as Mike suggested, refer them to the source. So refer them to the school district if they want to get data on the particular schools. But at that point, at least from my standpoint, I don't see a violation yet of fair housing. On the seller side, if the seller is going to consider factors in which prospective buyer they want to begin discussions and negotiations with based on some of that information, like if the conversation is directly between the buyer and the seller about schools, that's where it becomes more problematic, because now the seller has information that the buyer has shared and there's potential for implicit bias going on, and it becomes more difficult. But from a regulatory standpoint, and I think I speak for all the lawyers, we always want to look to the evidence. What is the facts going to show? What is the evidence going to show? And so, some cases are easier to prove, other cases are much harder to prove, and it really depends on what is out there. But I do agree with Mike. The safest approach is if you can refer them to another source. That's a safe way to go.
Thank you, Laura.
Okay, we have one more question about the website and then we'll move on. Can overlays and widgets be used on their own on a website?
Well, yeah, so the issue, you can definitely have a widget or overlay on a website. That is absolutely a possibility. That's the product they sell, right? But the issue is what does that achieve for you? It it makes the website more accessible, absolutely, to a percentage. For a large, if you have a very inaccessible website and you put an overlay on it, it's better than nothing. And it'll probably work, 60, 70, maybe even 80% of the time, depending on whether or not you customize that overlay. Some overlays will, they'll auto-generate alternative text for images, but you can go in on your own and you can customize it. And that alternate text is where the screen reader tells you what that image is. It can say, picture of a house, or more, more specifically, something, describing a brown house on a lake, etc. So, you can do that. The problem is from a litigation risk perspective, you're not really moving the needle. Like I said, I do work all over the country on access. I work everywhere, and I talk to all the plaintiffs' attorneys, and the website folks. They target, the website plaintiffs target people who use overlays. It's they see that you're using it, they're going to sue you. And it's in part because they don't like the technology and they don't want it out there. It's also in part because the technology, at least in my humble opinion, the technology threatens their business model. So I suspect at one point we will get overlays that will be better. Right now, the problems are A, they're not meaningfully tailored in all circumstances, and B, they have a problem initiating. Meaning when you go on the website, for a lot of people, they just don't work. And that creates additional problems. So yes, you can do it, and it will work on your website, or it should work on your website. But from a litigation risk perspective, I don't think we're there yet. And on accessibility perspective, it's close, but it's still not there. So
Thank you very much. So Eva, we have some questions for you now. When qualifying multiple family members for a loan, will the lender consider everyone's credit scores as an average, or will approval be based on the applicant with the lowest score?
The approval is based on the applicant's mid FICO score of the lowest of the four. And this is why rapid rescores become so important, because if we, as a lender, we see that there's a way for this family or the individuals to be able to increase their FICO score and get a better interest rate, or maybe go from an FHA to a conventional, that should be our commitment. Figuring out a way to assist them so that they're not stuck with the lowest FICO score.
Got it. Thank you. And then you showed some slides of the disparage between white homeownership versus Hispanic. Do you have it? Is homeownership broken down by state?
That wasn't my presentation, that was somebody else's.
Oh, okay. Okay.
And Mike's. I think.
Okay.
Yeah, actually, so I saw that question, and can I put a link? I'm going to link a PowerPoint presentation. It's readily available on our NAR website. I'm not sure seeing it.
I can get that link and we can send it out with all of the material.
Okay, yeah, it's well, actually, I don't know if I share my screen. I could really quick. I actually pulled it up, so
Okay. And then everyone can screenshot it.
I'll try to do this quickly. Yeah. So I don't know. Can you all see that?
Not yet.
Okay. Okay. How about this?
There
Okay.
you go.
Okay. So you see the map here in blue.
Mhm.
So PowerPoint presentation. So you see, this is, I think this snapshot is from 2018. It's from our research staff, Lawrence Yoon, who is an NAR celebrity. He's sort of our head of our research. And so here's kind of a state-by-state breakdown. I'm not sure if you can see that. This is, I think, from 2018, based on the census. And this is for African-American alone, percentage rate of home ownership. And then Asian, Hispanic, Latino, and then white alone. So I don't know, Lori, I'll maybe try to share that link, readily available. You can just Google search and it'll pop up, home ownership rate, NAR, it should come up.
We'll take care of that.
It was interesting to note that the southern states had a higher rate for the minorities than California did. So yay for us. Anything else, Laura? Because we're getting close to the witching hour here.
Yeah, we have a few more. So there's some questions about the term master bedroom. What should maybe the alternate use be?
So I've seen a lot of primary
Primary,
primary bedroom. I haven't seen any others. I don't know if anybody else out there has seen other examples, but definitely just primary. I think that is a proper adjective that explains, the biggest bedroom of the house. I think it's a suitable substitute for master.
Okay. And then this is for Mike. You're already up here. Could you restate the items that would fall under the disparate impact, specifically when it applies to prerequisites?
Just so some examples of prerequisites. Yeah, I would say, having to show a full-time employment has been the subject of litigation. Showing, I had an interesting question, an example of a prerequisite for an available property in order to come and see the home and do a walkthrough, you had to produce a pre-approval letter. And while, if it's applied equally to everybody, it probably wouldn't be a violation, that type of prerequisite. And the reason why the home seller wanted to do this was because of COVID, and they didn't want, tons of people coming through their home just to kind of, get a sense of the market or other reasons than say being a serious buyer. And the guidance to that as well, if you're applying it equally, it's probably not an issue. However, as we all know, showings can pop up last minute, right? You have a friend, another agent who says, hey, I have a potential buyer who just saw the listing. They want to come see it. The only time they can come see it is this afternoon. And so you might make an exception. And so you want to obviously treat everybody fairly, equally. So, you know, the source of income, you tend to see some of those disparate impact prerequisite issues. And then the most common one is probably a criminal record. So those are the kind of two biggest examples. But, you know, shoot me an email, mrohde@nar.realtor. I'd be happy to provide some more, you know, with a little bit more notice.
Okay. Let's,
All right, well,
do you want to keep going or do you want to just?
I work for you. What do you guys, what do you guys want? I mean, I know this gentleman, this lady may have other commitments, and so I want to be respectful of that, but
Yep.
some of us need to get to the airport. But no, we have a few minutes if it's okay with everybody, if you've got a few
Okay.
more questions.
We only have maybe 4 or 5 questions. About access to a property. What if we have an office in an older building that does not have elevator to allow someone in a wheelchair access to my floor where my office might be located? What are the possible issues in exposure given ADA laws?
Yeah, so yeah, so what you have there is assuming it's a pre-existing facility. That means the ADA's effective date for Title III, that's public accommodations, is January 26, 1993. So assuming it's constructed before that date and hasn't been meaningfully altered, the element hasn't been altered, that's changed, then you're only required to do readily achievable access barrier removal. Readily achievable means can be achieved without great difficulty or expense. Installing elevators is not something that can be achieved without great difficulty or expense. It's not readily achievable. So under that circumstance, what you would do is we have that catch-all, 28 CFR 36.302, which is the reasonable modifications to policies, practices, and procedures. So if, let's say, by way of example, you planned on meeting that person on the 3rd floor and they're in a wheelchair, you meet them on the 1st floor. You find you meet with them in a space down there, or you meet with them somewhere else, or you if you normally don't do a telephone call, maybe you do a telephone call, or however it is. So the issue is on physical access. You don't have to do you only have to do readily achievable for pre-existing facilities. There is a footnote to that, and that is the ADA. Similar to the fair housing construction laws, it prohibits the construction of a new construction facility that's not compliant with accessible guidelines. There's a 1992 ADAG, it's Americans with Disabilities Act accessibility guidelines, and a 2010 version of it. So let's just say you buy a facility from somebody else that's new construction, and you didn't, and it's not compliant. Well, we litigated that issue regarding the Ritz-Carlton Half Moon Bay, and Justice Breyer's brother, ruled in our favor and concluded that you're only required to do readily achievable access barrier removal under that circumstances. And what that means is you didn't violate the law by building the facility, in non-compliant as a new construction facility. Instead, you have this facility, so now you're required as a pre-existing facility to do readily achievable access barrier removal. So under both circumstances, the elevator would not be required. Again, elevator is the same thing. We do see that also in the fair housing context for dwelling units as opposed to public accommodations. That's
Matt, can I ask a question real quick, Laura? Matt, what if you're doing substantial remodel? Do you have to then bring it within compliance of ADA?
Yeah, there's a couple of things that go with the remodeling. First of all, if you do a substantial remodel, the building department's going to require you to allocate a certain percentage, generally 20% of your remodeling, or up to 20% to accessibility. Second of all, generally speaking, if you alter an element, the entire element needs to be brought up to code. So I want to point out that the readily achievable aspect only applies to the federal standards, not the state standards. So keep in mind, we have two different standards, right? We have the California Building Code, Title 24, Section 11B applies to access, and then we have the federal code. So you are grandfathered in to the California Building Code at the time of construction. That's the time of the certificate of occupancy or the pulling of the permits, and that is the building code you comply with, which is triannually updated. So if you alter the element, the entire element needs to be brought up to code, both for the ADAG as a new construction, that's Americans Disability Accessibility Guidelines, the federal standards, and the California Building Code. So what is the altering of a whole element? That is our altering of element. That's a subjective issue. A lot of case law on that goes both ways. Generally speaking, it's going to be construed in favor of access because it's remedial statute. So you could imagine if you do one parking spot in a parking lot, they're going to say, okay, the entire parking lot needs to be brought up to access. But again, what are you doing? Are you slurry sealing and painting it? Okay, you have to do that. But if you're repaving it, you're going to have to repave the whole place. Again, the alteration of the element. And that's the issue. So definitely if you're doing a significant remodel, involves structural aspects, you're usually going to have to put in an elevator. There is a for physical access. I know we weren't really talking about physical access on this. California, similar to Texas, Texas has a RAS, but California has a CASP program, CASP. And the CASP program has certain individuals who are certified by the Division of the State Architect to go out to your facility, inspect it, tell you about your facility, and tell you whether or not it's compliant or non-compliant. And if they come back, if they tell you some problems, you fix it, they come back and they certify as meets all applicable standards, those UNRUH damages for physical barriers drop down as low as $1,000 per incident. Keep in mind, if it is or isn't CAS certified, you're already, those of us who are doing leasing, you're familiar with that disclosure that you have to put in the lease documents. At least on the state level, there's a disclosure, and then there's city level, municipal required disclosures as well that pertain to your CASP inspection and the results. It wasn't certified as meets all applicable standards, has been CASP certified, et cetera. So that goes into play there. And that person could definitely help work with you on the aspect. And some building departments, by the way, do get a little bit overly aggressive, and they'll require, or they'll ask you to do things that you're not required to. And we have fought successfully won against municipalities on those issues in the past.
Great.
Or anything else, or?
Well, we've got two more questions, and then somebody wants Eva's contact information. Okay, so here, this is a question from Sybil. I've discovered that I have much better luck getting realtor responses and cooperation after removing my photo from my business cards. I am a Black woman. It was creating a negative impact on my buyers as well. I'd much rather focus on selling real estate than filing complaints against my colleagues, so removing my image may be a permanent decision. Have you found this to be an issue? If so, what do you recommend to brokers when it comes to addressing this type of bias?
So, John, should I take this one, or
Sure.
anybody else?
It's a sad question, but yeah, go ahead.
Yeah.
Sure. So yeah, I echo that completely. I have not heard. First of all, I have not heard of this as an issue, and I no doubt, obviously, believe that it is to be an issue and could potentially be a violation, and is not obviously not within the spirit of the Fair Housing Act. In terms of advice, first of all, telling your story, having the courage to even ask this question, I think is one way. Everybody listening on this call right now will be made aware, and these implicit bias issues that we're not even aware of that exist. And so just having the courage to talk about it, I think, is a step. And again, it's probably not advice you're looking for. Outside of discussing it directly with other brokers, agents, potentially filing complaints, I would say maybe reach out to housing groups that, you know, could maybe conduct testing, right? That they could maybe implement a program where they could do independent testing to see if there's an issue there that they could then undertake and file a complaint, sort of not necessarily on your behalf, but to address this issue. And so there are resources out there, but it's obviously a sad situation. And hopefully, you know, over time, these are the types of issues that we hope to improve and remedy. So I've not heard of that as an issue, but definitely something to be aware of and concerned about.
Okay, we have one last comment, and this is directed for you to you, Mike. Have you heard of the company called Accessibility? This is the company CAR recommends to get your websites ADA compliant and maintain them.
So I think that one might have been addressed to Matt. I have not heard of that company, but I will defer to Matt, being the expert on the ADA.
Yeah, I'm very familiar with Accessibility and the relationship with CAR. CAR doesn't recommend them. They have is a list of potential solutions. Accessibility is one of the overlay providers. And they have, like I said, they'll give you all kinds of great promises in their marketing materials. But I've worked with them. I've been adverse to them as well. So I've been on both sides with them, and I can neutrally say that they have the same problem that all overlays do, is that the technology is just not there yet. And it basically puts a target on you for using it. The better solution, as Lainey Feingold, one of the pioneers in access, has on her website, she talks about is, you know, working with your developer to achieve access as opposed to using the overlay. We're all very hopeful that someday the technology will get there. Just right now, it's just not there yet. And again, if it puts a bounty on you, it's going to increase your litigation risk. And if you're buying it to avoid litigation risk, that doesn't really make sense. So.
Okay, well, that's it. That's it for the questions. John, you're muted.
A lot of people were probably cheering at that fact, but so how do we get these phenomenal presentations that each of these people did?
Oh, yes. So everybody that registered will receive a copy of the presentation, and then we'll also include all of the handouts as well.
Okay, and contact information as well, because there may be other resource questions that they have. All right, well, first of all, I want to thank the four of you for giving your time so generously. And it wasn't just the time you gave us today, the preparation of the paperwork and frankly, the service that you provide to the industry. So I want to thank you on behalf of both associations, and I want to thank the people that showed up today for giving us their time and learning about this incredibly important topic that hopefully we will see some significant changes, as we've had, frankly, for the last couple of years, but really start seeing some significant changes. So that the question that Mike answered won't be questions. We won't see those kinds of questions anymore. So on behalf of the associations that presented today, and on behalf of Laura and Lori, and on behalf of our speakers, I want to thank you. And again, thank the speakers, and we'll see you next time. We got a lot of programs coming up for the rest of the year, so it should be a lot of fun, a lot of stuff to learn. Thank you guys very, very much.
Thank you.
Thank you.
Thank you,
Hey,
everybody.
John,
Yes.
did you see Marion's question in the chat?
Yeah, I did. The answer is no. I don't know anybody up there.
Okay,
I was going to send her an email directly.
okay, all right.
Thank you all.
Bye,
Bye-bye.
everyone.
Or as they say where I'm going, aloha.
Exactly.